Viewers, Namaskar. It gives me immense pleasure to address you on our auspicious 80th Independence Day. Our country is vibrant and prosperous, and more prosperity is going to come in the coming years. Very soon, our country is going to be one of the superpowers. Our best wishes my best wishes to all of you, and I pray to Almighty so that our country grows. Now, having said that, I've come with a new presentation on various judgments of pertaining to insolvency and bankruptcy code. These judgments have come in Supreme Court and NCLAT and also High Court, various high courts during end part of July and between beginning of August up till middle of August. So with this, I do hope you are going to like the presentation, and with this, I take you over to the presentation.
We are on the screen of section 3, subsection 27, which deals with the topic property. Look at the dashboard, there are a number of topics. Our topic of interest is topic number 4, which says that leasehold and development rights are assets of CD under section 3, subsection 27, and possession of the corporate debtor of the property needs to be protected. We have done earlier cases on this particular subject. However, this particular case which we are going to deal with is a Supreme Court judgment. It has got nothing to do with insolvency bankruptcy code. But having said that, I'm personally doing a case in which Slums Act is involved. So it's a CIRP in which Slums Act is involved. Even in Maharashtra, there is MHADA Act, Maharashtra Housing Development Act. So it is necessary for professionals as well as everyone to have an idea about these acts, which are actually beneficial, which are public laws, and which are not in conflict with insolvency bankruptcy code. And the rights of people have to be protected. So that is the reason we are doing this particular case. The cases of Mrs. Mahabano, contractor, and another versus Mrs. Kalikun, developers, and others, civil appeal so-and-so, Supreme Court. This is a late July judgment. Now, in this, what happened? There was an old building which was getting reconstructed under MHADA. There was one lady staying in a flat along with two other occupants, and which was very much recorded. Now, this lady died, and obviously she left the rights to the person or to the lady she was staying with. Now, this building there was delay in developing the building, but ultimately when the development and the management of the developer also changed, when the new promoters came in, they declined to give possession to the other persons who are staying in the flat. Supreme Court dealt with this particular case at length and decided that no, this has to be given. Now, this is a very important thing because, like we have seen that in the case of Anudan Properties case, Bombay High Court held that SRA, Slums Act, prevails over insolvency bankruptcy code. Even in MHADA, also may prevail over insolvency bankruptcy code. So that is why this case is important. And let me take you over to without going into, and I would request my viewers to go through the excerpts of the judgment, which is quite long, and it will impart good knowledge about it. So let me take you over to the slide which I have prepared for you. Now, what did the Honorable Supreme Court say? Rule 33(7), under which the proceedings for redevelopment or reconstruction clearly provides for application of MHAD Act and specifies landlords and occupants of the seized building. So, MHADA Act specifies who are the landlords and who are the occupants of the building which is being constructed. Item number 24 of the public notice issued by the respondent. At item number 24 of the first column, bearing the name of the tenant, appears Mrs. Kul Peshotan Unwala for and the column for occupants along with the original tenant, the first appellant name is also shown. So that means the original tenant and other occupant is shown in the public notice. Relevant is the fact that public notice issued by the developer or owner as early as 2010, when the original tenant was alive, showed the first appellant to be in joint occupation of the premises of the old building. So she was not alone, she was in joint occupation. The NOC issued by MHADA stipulates that all occupants of the old building shall be accommodated in the redeveloped building and given equal carpet area as occupied by her for residential purpose, subject to minimum and maximum as provided under MHADA Act. So the law says whosoever state, you have to provide equal area. In this, actually, what happened? They offered lesser area to the occupant. And that's why the case took place. The PAAA, executed on 17/10/2019, concedes to the first appellant 219.81 square meters plus 35% of fungible area in all 309.98 square meters. And thus one flat of 1227.42 square feet and two flats of 1054.74 square feet each. So they were supposed to get three flats, one for 1227.42 and two flats for 1054.75. Despite the further communication of MHADA to the developer dated 21/11/2022 to comply with the extended time limit up to 21/9/2023, the flats in the reconstructed building were not handed over. The anomaly pointed out by the learned senior counsel, the PAA, in its recital, having noticed the pendency of a probate application, which admittedly was initiated much later, does not vitiate the agreement as such. Probate is altogether a different thing. But what PAA has mentioned, that this flat needs to be allotted, so that cannot be held up because of probate. The developer cannot casually, after all these years having obtained the consent leading to vacation of premises, cannot turn around and challenge the very claim raised by the first appellant as an occupant. The mere fact that fungible area was not fully utilized cannot also be a ground to allow the developer to resign from its agreement to redevelop and allot alternate premises to the occupants in the old building as agreed upon. The civil suit itself is misconceived and malafide in the context of undertaking given by the High Court, which is sought to be resiled from, and which more than reflects the conduct of the developer and landlord. So Supreme Court came heavily on the developer and the landlord. The first and second respondents are directed to execute PAA and hand over possession of 3 apartments in the new building within a period of 2 months. Failing which, the appellants will be entitled to damages at a monthly rental value for 3 flats in the location, which they would be entitled to recover from the first and second respondents. So that means what? The land, the area which has been provided in the original agreement must be adhered. You cannot, after constructing the building for you increasing your profit, reduce the area at your discretion. So this is very important. Like SRA, as I have mentioned, and MHADA, these are very, and this is the reason why Mumbai has developed so much. This is the reason. You see, the buildings are getting old, so they're getting reconstructed. Slums are getting vacated, but the slum dwellers are getting rehabilitated and new structures are coming up. So as insolvency professionals or as developers, We should know about the nuances of these acts, and these are very important. So with this, we move on to the next slide. We are in the dashboard of topics of section 5, subsection 8 on Guide to IBC website. Section 5, subsection 8 deals with financial debt. Our topic of interest is topic number 41, which says that an operational debt does not transform to a financial debt as a consequence of circumstances. An operational debt remains an operational debt. It doesn't transform to financial debt. And a financial debt always remains a financial debt. It does not become an operational debt. So this is an interesting thing. And we are dealing with the case of the South Indian Bank Limited versus Brijesh Singh Bhaduria, Company Appeal so of 2025. This is also possibly a late July or early August judgment. In this case, what happened? South Indian Bank was extending working capital facilities in the sense, by the way, of bill discount. The company was raising bills, or rather, they were paying. They were actually paying to the corporate debtor. They're paying to the supplier, and later on, company after realization, company was repaying to the bank, and this process was going. South Indian Bank came and filed a case against the corporate debtor. NCLT went in NCLT and then went to NCLT. The South Indian Bank, it's a bank. So its main defense was it was a bank and it was extending financial accommodation. So why should it not be treated as a financial debt? The court dealt with the subject. It's a long judgment and an important judgment at that. And it is segregated into segregated into different chapters. So that makes it more interesting a read. I would advise the viewers to go through the excerpts of the judgment. Please do that. Now, having said that, let me take you over to the slide which I prepared for you. We have come to the slide. Let us see what the court has said. The court said that the financial debt under Section 5, subsection 8 includes amounts raised under transactions having commercial effect of borrowing and the amount of any liability in respect of any guarantees, indemnities for foregoing others as noted above. Now, Section 520 provides that a person to whom operational debt is legally assigned to or transferred is an operational creditor. 520 says that an operational debt becomes an operational debt, remains an operational debt, even if it is transferred to another person. In assignment, the operational debt at no stage did any amount pass from the appellant to the corporate debtor. The appellant was that South Indian Bank was paying to the buyer. So the money was not coming to corporate debtor. Corporate debtor was buying and South Indian Bank was paying to it was a purchase facility in which they were presenting the bills of the seller and South Indian Bank was paying to the seller. So no money was coming to the corporate debtor. Corporate debtor instead was later on replenishing the money to the South Indian Bank. What appellant acquired by assignment was the very same right the suppliers already possessed, the right to be paid for the price of goods and sold and delivered. So appellant acquired rights in the assignment of exactly the rights of the corporate debtor. Nothing else more. The obligations of corporate debtor to pay the appellant on due date is not fresh or independent obligation created by a loan. It is the very same trade payable that always existed, now owed to assignee instead of original supplier. So what happens? The originally corporate debtor was supposed to pay for the bills, the purchases. So herein, they were, instead of paying to the seller, they were paying to South Indian Bank. So no extra loan or no extra facility was created. This ordinary compensation or a compensation of financial earns by paying a trade receivable early. It is not consideration for a loan. It is not money given or let the corporate debtor to raise funds it did not otherwise have. It was not any kind of a concession. It had not given a loan to corporate debtor. It was just a discounting facility. The adjudicating authority has correctly applied the ratio of Mudraksh and rejected applicant's claim in the financial debt. We have in the website, if you go to this, you will find Mudraksh Investment Private Limited versus Vijay Singh Bhaduria. It's the same RP. Company appeal so and so 2023. It's the same judgment. The money was paid to discharge trade debt of corporate debtor already owed for goods received. It was not paid to place funds at the corporate debtor's disposal for its own use. So the money was paid to discharge trade debt of the corporate debtor. An independent and identical transaction does not change the character under the code, depending upon whether the financier happens to be a bank or an NBFC. The transaction remains the same. In Mudraksh, what had happened was Mudraksh was an NBFC. Here it is South Indian Bank. Just because it has become a bank, it does not change the character. The resolution professionals communication dated 18/12/22 and impugned order upholding the classification are correct in law. The resolution professional did not ignore appellant's claim. He classified by a recent communication dated 18/12/22 as operational debt. The omission of appellant's claim from the plan is attributable not to any illegality in the classification exercise and or in the CIRB, but to the appellant's own delay in complying with the classification. So this is an important, interesting read. And this is not new. You have dealt with this. I have done Mudrak's investment case earlier. But this would refresh your mind on this particular aspect. So with this, we move on to the next case. Viewers, we are on the screen of Section 5, subsection 21, which deals with operational debt. We are going to deal with a Supreme Court case of 12th of August. Now, this case has got many aspects, one of which deals with operational debt. And the topic which we have is topic number 21, which says that disputes that arise from breach of a contract cannot give rise to an operational debt till the time the debt becomes crystallized and legally enforceable. This has got another angle, which is limitation. Limitation, you will find this case in section 238A, in which the topic is the understanding of limitation in case of EPC contract for the purpose of contesting substantive claims by way of either a civil suit or arbitration is not applicable for insolvency application under Section 9 of IBC. This is a dynamic case. The case is of Srinivas Reddy Velagala versus Sravanti Infratech Private Limited, civil appeal so and so of 2021. As I told you, this is a Supreme Court judgment and which came out yesterday. You will find this case in Section 9 also. In fact, I have put this as a separate topic in CIRP in Section 9. And topic number 46, if I'm not wrong. Yes, insolvency of an EPC company. So Srinivas In topic number in this section 9, you will get the entire case, the excerpts of the entire case. The case spans 62. The judgment spans 62 pages. Of course, it will be much shorter. But in section 9, you will find the entire case, whereas in 521 and 238A, these are the main topics on which we have basically, you see, pre-existing dispute is not so important. So basically, they have analyzed what constitutes an operational debt, then the limitation. These are the two main factors, and especially concerning EPC contractor. EPC contractor, and that's why this case. Now, in this particular case, now first we should understand what is an EPC contract. EPC stands for engineering, procurement, and construction or commissioning, whatever you say. So a contractor takes charge of engineering, procurement, and then commissioning. So the total thing is EPC contract. In 2010, a party gave EPC contract to the appellant. In 2010, awarded a contract of 827 crores. They were supposed to make an initial payment. EPC contract usually comprises of various milestones, and the payments are based on the milestones. So they were initially supposed to pay 10% on completion of the first milestone, and they paid about 50 crores. And then the party, the EPC contractor, they arranged for everything. They started mobilizing the products. Immediately, they after completion of the second milestone, they raised the bill, no payment. Then they kept on the third and fourth milestone also got completed, but no payment. So they ultimately sent legal notices to the party in 2014 and 2015. And then thereafter, after about an elapse of 4 years, that is 3 years, in 2018, they filed a Section 9 petition in NCLT, which came to be admitted. The petition and claiming a due of 1292 crores. The petition came to be admitted. The petition was challenged in NCLAT. Even NCLAT upheld the claim of NCLT. The basic question was whether limitation would be attracted because the invoices were raised in 2010 and 2010 and 11, and they were accepted in 2012. But the court held that the EPC contract is subsisting. So in such case, the limitation doesn't apply. So the matter went to Supreme Court. It's, as I said, it's a lengthy judgment and an excellent judgment. Court has analyzed it and they have broken it into various parts. Subsistence of EPC contract, amount claimed, whether it is operational debt, determination whether EPC contract entered into between operators is frustrated by influx of time, what is frustration of contract, and pre-existing dispute, and then rationale of limitation, and what is speciality about limitation with respect to EPC company. So, as I said, this judgment is a fantastic judgment and spans over so many things. So, in order to make things simpler and understandable, let me take you over. Let me stop the slide share here, screen share here, and take you to the slide which I prepared for you. Now, as I say, pre-existing dispute is not the main thing. Now, the first question is whether the EPC contract stayed or not. So, the EPC contract could have been terminated by both the parties. The appellant could have terminated it. The respondent could have terminated it also. But in the present matter, the EPC contract never got terminated. So it remained. The contractor raised the issue of contract getting frustrated due to effects of time, which the Supreme Court did not agree, because Supreme Court stated that efflux of time is a natural thing. And frustration of a contract takes place in the case of an event arising which uh, uh, which actually makes the contract impossible to take place. So nothing like that happened. So frustration of contract due to efflux of time was not accepted. In fact, Supreme Court held that suspension of work cannot be considered as supervening impossibility as part of the requirement under Section 56 of Indian Contract Act 1872 for the doctrine of frustration to apply. Thus, EPC contract continues to subsist. Now, EPC contract is a work contract which involves procurement of goods as well as construction of natural gas facilities. Therefore, all payments, all payments that parties agreed upon on completion of stages of the work mentioned in the payment schedule of EPC contract can be categorized as operational debt once they become payable. So every invoice for every procurement, every construction activity, once they got materialized, they were operational debt. But party, the EPC, they claimed damages. Now, Supreme Court was of the view that damages, whether liquidated or unliquidated, cannot be treated as an operational debt unless and until they are assessed and crystallized by way of adjudication by a court of competent jurisdiction. So damages have to be adjudged by, and they have to be crystallized by way of a judgment of a competent court. And NCLT and NCLAT are not courts. They're tribunals. So they're incapable of determining the scope of damages. So damages do not constitute. So disputes that arise from the breach of contract cannot give rise to an operational debt. At that time, debt becomes crystallized and legally enforceable. Since there is no record of suit or arbitration that assessed, adjudicated, and crystallized upon these claims, the amount claimed under the heads cannot be treated as operational debts. So, liquidated damages or damages which was claimed by the party are not operational debt. Now, we come to there was no pre-existing dispute. There was since, though court held that silence doesn't mean that acceptance. But with corporate debtor and making no correspondence whatsoever, raising no voice whatsoever, it was considered that there is no pre-existing dispute. But then came the question of limitation. Now, operational debt became due and payable on the debt that defaults, that is 15/2/2011 and 13/7/2011. The liability to pay in respect of both of defaults came to be acknowledged by appellant on 5/1/2012 and 3/2/2012 respectively. The default envisaged under Section 3, subsection 12 of IBC occurs on non-payment of a debt when whole or any part of installment of the debt becomes due and payable but is not paid by the debtor. So 312 says what? Default is non-payment of a debt, whether in full or in part. So what happened is that this 15/2/2011, which was accepted on 5/1/2012, and 13/7/2011, which was accepted on 3/2/2012, that these were the dates when these invoices were supposed to have been paid. They were not paid. So according to Section 312 of IBC, the default took place on the 3/2 and 5/1/2012. The mere subsistence of EPC contract will not give continuing cause of action in respect of defaulted amounts. So this is a very vital thing. The mere subsistence of EPC contract will not give continuing cause of action with respect to this defaulted amounts. For the purpose of determining the starting point of limitation, the governing principle is that each invoice generates its own date of default when it becomes due and payable. The debt amount mentioned in the demand notice was acknowledged by the appellant on January and February 2012. Therefore, the respondent was required to act on these defaults within 3 years therefrom, which was not done. The understanding of limitation in cases of EPC contracts for the purpose of contesting substantive claims by way of either civil suit or arbitration is not applicable for insolvency application under Section 9 of IBC. And on this ground, this case was dismissed by Supreme Court. They said that NCLT and NCLT both erred in admitting the petition. The admission of Section 9 of IBC application of the respondent was erroneous, and the same could not have been done without condemnation of delay as per Section 5 of Limitation Act 1963. So this is a fantastic case, and this gives an immense amount of learning to all of us. And we should all go through the excerpts of the judgment as featuring in the website of guide2ibc.com. And I would request everyone to go through it. We are on the screen of topics of section 14 of Insolvency Bankruptcy Code, which deals with moratorium. We have earlier heard about P. Mohan Raj judgment, Supreme Court judgment in the case of P. Mohan Raj, in which it is said that in the case of check bouncing, that is liability under section 138 of Negotiable Instrument Act, if the corporate debtor cannot be implicated, but the promoters and directors are. This particular case which we are going to deal with doesn't deal with check bouncing, but it's a home buyer case. So that is the reason I created a different topic. It is topic number 82, which says that a moratorium against corporate debtor does not give protection to the promoters and directors of the corporate debtor, and the proceedings can continue against them. This is a Supreme Court judgment in the case of, and that too very recent judgment, Tejas J. Shah and Amisha T. Shah and others versus Mantri Technology Constellations Private Limited, Civil Appeal so-and-so of 2025. This is an unusual case of home buyers, in which, as usual, the properties were not getting transferred. They went to NCRTC. And NCRTC stopped the case, stopped hearing of the case, stating that there is a moratorium existing against the corporate debtor. So, even though the directors and the promoters were all implicated, they said that they are not going to hear the case since there is a moratorium. The matter went to Supreme Court. And Supreme Court dealt with it. And this is a very good judgment. And it is and it has a tremendous implication with regard to home buyers. It all the more affirms the rights of the home buyers. So this case is of umpteen importance. And I would request my viewers to please go through the excerpts of the judgment appearing on Guide to IBC website. With this, let me take you over to the slide which I have prepared for you. Now, the Honorable Supreme Court said that once insolvency process has begun and moratorium is declared, amongst other things, continuation of pending suits and proceedings against the corporate debtor, including execution proceedings, comes to an automatic halt. We know that. The object of this moratorium is to preserve the assets of the corporate debtor during insolvency resolution proceeding and to facilitate orderly resolution. A moratorium against corporate debtor does not give protection to the promoters and directors of the corporate debtor, and that proceedings can continue against them. This comes from what? P. Mohan Raj and others versus Shah Brothers Ispat Private Civil Appeal so of 2018. So what it says, a moratorium against corporate debtor does not give protection to promoters and directors of the corporate debtor, and that proceedings can continue against them. The protective sweep of a moratorium must remain in the four walls as carved out by the statute. It ought not to be expanded in manner that 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 stultifies the remedies envisaged under Consumer Protection Act unless expressly provided. Here, Consumer Protection Act was the subject of the suit. It can be insolvency proceedings also, or it can be anything else. I mean, it can be insolvency bankruptcy court also. In the present case, respondent one alone, the corporate debtor against whom CIRP has been initiated. No independent moratorium or independent protection operates in favor of respondent 227. 227 are what? They are the developers and the landowners. The NCRDC was not justified in rejecting the appellant's prayer to proceed with the complaint against the rest of the respondents. That's what I told you. NCRDC was not justified. The commission was required to adjudicate the complaint against the said respondents and determine upon consideration of the rival proceedings and objections whether any liability could ultimately be fastened upon them. So this is exactly what we see is reflection of P. Mohan Raj judgment, but on a different subject with respect to home buyers. And Supreme Court once again upheld the right of the home buyers in this particular judgment. So this makes it an exceptional judgment and must read for all. With this, let us move on to the next slide. We are on the dashboard of topics pertaining to Section 14 of Insolvency Bankruptcy Code on Guide to IBC website. Section 14, as we know, deals with moratoria. The particular case we are concerned with deals with topic number 83, which says that the scope of the jurisdiction exercised by the adjudicating authority has to be determined with reference to the nature of the relief granted and not merely by reference to the provisions cited in the application. The case is of Amit Kumar Agarwal versus Tasvi Resolution Services LLP, Company Appeal so-and-so of 2025. Now, this is an interesting case. This particular case was instituted by the RP under Section 66, Section 60, subsection 5, and Section 74 of IBC. The adjudicating authority, not only adjudicating authority, wrote gave an order directing the appellants to contribute a sum of 8 crores odd to the account of corporate debtor, and also requested central government to initiate and also Insolvency Bankruptcy Board of India and Ministry of Corporate Affairs to take action against the corporate debtor under Section 74 of the Act. The main ground on which this was challenged in NCLAT, and the main ground for the appellants was that this case was instituted under Section 66, along with Section 60, subsection 5 and 74. The main ground was Section 66 was not applicable. There was no fraud involved. So, NCLAT, this pertained to selling of a property after commencement of CIR. So NCLAT made an in-depth study of the case and stated that the jurisdiction, though this Section 66 is not important. This deals with the matter of selling of a property during the persistence of moratorium, which was violation of Section 14 of the Act. And Section 60, subsection 5 empowers the adjudicating authority to exercise jurisdiction on the matter. And the adjudicating authority did not go into Section 66. So this is a very important case. And Section 74, as you know, that the Insolvency Amendment Act 2026 has omitted Section 74. So this is a must read for all, this particular judgment, and how the NCLAT has arrived at this particular. This also deals with, you see that the definition of Section 60, subsection 5, what is Rule 11, and all that. So this is a must read for all. Let me stop the screen share here and take you over to the slide which I prepared for you. Appellant and the other suspended directors were directed to contribute 8 crores, as I told you, on account of the corporate debtor, on the ground that the said amount was withdrawn or dealt with during the subsistence of moratorium under Section 14. The adjudicating authority also directed that a copy of the order be forwarded to IBBI and the Ministry of Corporate Affairs, that is MCA, for taking action as may be considered appropriate under Section 74 of the Code. IA number so and so was initiated under Section 66, under Section 74 and 60, subsection 5 of the Code, read with Rule 11 of NCLT rules, and not exclusively under Section 66 of the Code. The mere fact that Section 66 formed one of the statutory provisions invoked by appellant does not by itself determine the source of every relief that could ultimately be granted by adjudicating authority. It comes out very clearly the grounds of appeal as well as the prayers in the application that this relief has been sought on the grounds of violation of moratorium under Section 14, read with Section 60, subsection 5 of the Code and Rule 11 of NCLT rules. The scope of the jurisdiction exercised by adjudicating authority has to be determined with reference to the nature of relief granted and not merely by reference to the provisions cited in the application. The sale of property was made despite order dated 16/10/2023 passed by appellate tribunal, by which permission was specifically declined to sell any property of the corporate debtor. So this matter had gone to NCLT earlier, and permission was specifically declined by order dated 16/10/23 to sell the property. Emphasis of the adjudicating authority was on the effect of transaction on the assets of the corporate debtor during CIRP and not on adjudicating the personal liability of the applicant under Section 66. The adjudicating authority consciously refrained from adjudicating allegations under Section 66 and examined the issue of violation of the moratorium independently. As I say, they did not look at Section 66. They looked into the violation of moratorium. It directed restoration of the amount on the account of corporate debtor in exercise of jurisdiction under Section 60, Section 14 and Section 60, subsection 5 of the Code, and the impugned direction. As Section 74 of the Code is not part of the statute anymore, directions contained in the impugned order relating to the said section have become infructuous. So this is a very, very important case. So mentioning a section in the petition is important, but it is not mandatory. As far as the adjudicating authority is concerned. So long Section 60, subsection 5 was mentioned with NCLT rules 11, NCLT rule 11. And that gave ample jurisdiction to the adjudicating authority to judge the case from the point of view of violation of moratorium. And this is what makes this case exceptional. So with this, we move on to the next item.
We are in the midway of our presentation. I hope you liked the judgments which have already been presented. Please do like our video and share it with your friends and send us comments. With this, let us move on to the next part of the video.
We are on the dashboard of topics pertaining to Section 22 of Insolvency Bankruptcy Code on Guide to IBC website. Section 22, as we know, deals with appointment of resolution professional. We are dealing with the topic number 7, which says that the change, replacement, or continuation of the IRP/RP must be left to the wisdom of the COC, and the tribunal should only interfere when there are exceptional circumstances. Now, why this case is important is because, despite the fact that all the insolvency professionals, they have to appear for a limited insolvency examination, they pass. And then there is also all the financial institutions and various other organizations. They have a system of empanelment of IR, insolvency professionals. And they want their desired person to be there. Now, if the desired person is not there, unfortunately, in many cases, the financial institutions, they resort to any kind of, they create so many objections, and literally insolvency process or CIRB process or liquidation process to a grinding halt because of the ego clash. And unfortunately, insolvency professionals become are victims of such circumstances. I'm sorry to say, but this is exactly what happens. Now, this case is of Catalyst Trusteeship Limited and another versus Sri Suman Kumar Verma, IRP Company Appeal Suence of 2025. In this, what happened is this is a home buyer case in which initially the claim was received from appellant for 109 crores, and he was given from appellant number 1 of 276 crores, which was admitted at 267 crores odd, and they were given 84.23% rights. Subsequently, in February, the claim of appellant number 2 was admitted for 109.9 crores, and the claim was submitted, and 102 crores was admitted, and they were given 17.47% voting share. Now, obviously, 17 plus 84 makes it more than 100. So, obviously, if 17 was given, then the voting share of appellate number 1 had subsequently reduced marginally. But there later on, the home buyer's claim came. And the voting rights of appellant 1 and 2 reduced consequently, and it was more than it was, and they did not, and thereafter they did not have the 66% voting right. The home buyers retained more than 66% voting right. Now, the appellant number 1 and 2 wanted to change the IRP, which home buyers were not willing. And the case and the CIRP came to a grinding halt because of tussle. This went to NCLT and ultimately it went to NCLT. And it's a long judgment. It's a long judgment. And too much of complication. Exactly what I told you. The matter was the financial institutions complained to IBBI also, which is an usual practice. Because IBBI, unfortunately, I would like to say this, IBBI doesn't take any action on COC. Invariably, the insolvency professional becomes the scapegoat. So this is an usual practice. The harassment goes on. But anyway, let us look at NCLT judgment. Let me stop the screen share here and take you over to the slide which I prepared for you. The Honorable NCLT held that according to own admission, the appellant number 1 has filed claim for 276 crores, and his claim for 267 crores was admitted, and he was given 84.23% share. Similarly, appellant number 2, they had submitted claim for 109.9 crores or more than that. I mean, this is in million form. So whatever, and the claim of 102 million was accepted and was admitted and was assigned 17.47% share. Depending upon the nature and quantity of debt, that it's duty of the IRP or RP, as the case may be, to maintain up-to-date list of claims. We know that. The only fact that the claim of the creditors has not been admitted in full may not be the sole ground to remove an IRP. IRP is not bound to accept the claim in whole, entirety. You can, based on the verification of claim. And just because the claim has not been admitted in full, that cannot be the sole ground to remove an IRP. If after verification of any claim of a lesser amount has been admitted by IRP, in contrast to what has been claimed by the creditor, the integrity of the IRP could not be doubted on this score alone, which is a very vital thing. The COC was reconstituted on 8th March 2025 and updated claims were filed to IBBI and adjudicating authority through IA number 424 of 2025. As on 8th March 2025, there are 2 financial creditors and 134 home buyers who are members of the COC. This factual position has not been disputed by appellants. The IRP was advised by the IBBI to take appropriate steps and address the deadlock among the COC members by considering approaching learned adjudicating authority. It is evident that there was a deadlock within the COC on various issues, but the composition of the COC had been such that the creditors in a class were supporting IRP, while the appellants were apprehended by a reduction of their voting share in COC. The replacement of the existing IRP and appointment of a new IRP or RP was put up for voting in the second, third, and fourth COC meeting and was rejected as per Regulation 17.3 of CIRP Regulations 2026. The IRP was directed to work as RP. If IRP is not rejected, IRP is appointed continuing, then he is supposed to be deemed RP. So the IRP was acting as a deemed RP. In the 13th COC meeting held on 24th March 2026, the agenda to approve IRP as RP was approved with 67.42% vote share. Thus, IRP has been appointed by the COC as RP. The requirement is 66%. The home buyers held 67.42%. So IRP was appointed as RP, and that is final. The change, replacement, continuation of IRP or RP must be left to the wisdom of the COC, and the tribunal should only interfere when there are exceptional circumstances, which in our considered opinion are lacking in this case. So, you see, this entire, I don't know why, of course, I don't want to mention anything regarding the judicial prudence of Honorable Appellate Authority. But in my opinion, they should have taken a stringent, at least something should have been mentioned for the appellants who unnecessarily held up the process, and they are responsible for the loss of time. So anyway, no cost was imposed on them. But however, it exemplifies what nuisance the COC often some financial institutions resort. With this, we move on to the next slide. Before we come to the topic for discussion, let us have a read of section 333, subsection 6. It will be worthwhile to say that subsection 5 was omitted by Insolvency Bankruptcy Code Amendment Act 2026. And It was substituted with subsection 6, which says that where a liquidation order has been passed, no suit or other legal proceedings shall be commenced, or if pending at the date of the liquidation order shall be proceeded with by the liquidator on behalf of the corporate debtor, except with the leave of adjudicating authority and subject to such terms as the adjudicating authority may impose. Understood? Now, let us come to topic number 35. What does it say? If the proceedings are initiated without leave of the court, if proceedings are initiated without leave of the court, the proceedings shall be unauthorized. However, it shall become competent from the date the leave is granted. That is, if you are in urgent need and you move, initiate the proceedings or defend yourself, and at the same time you apply to adjudicating authority. So, if you are doing it prior to obtaining, it is unauthorized. But once the court permits, it becomes an authorized. Uh, it becomes you are competent as a liquidator to move once it is permitted by the court. Our case is of Techpro Systems Limited in liquidation versus Reliance Infrastructure Limited, commercial arbitration application so and so of Bombay High Court. This is a recent judgment, and this is a beautiful judgment at that. I would strongly recommend my viewers to go through this. In this, what happened? The same thing. 33.5. The liquidator did not initiated that, defended a case, initiated action, but then thereon subsequently he went to NCLT and NCLT granted the permission. The question arose that the action of the liquidator to move, was it legal or illegal? The court, Bombay High Court, while dealing with it, dealt with Section 28, wherein it is specifically mentioned that it mentions that any action by the resolution professional without obtaining it provides certain acts which RP does. It cannot be ratified. It has to have prior permission of the COC, without which it becomes illegal. But whereas Section 33, subsection 5, does not mention anything of that sort. So the court analyzed the thing and came with a view, which is very important for us. And we have mentioned this because if we go back, we also have another case, Slimline Realty Private Limited versus Jigar Bhatt. This is company appeal. But this particular case, Techpro System Bombay High Court has analyzed it in a completely different way. And that's what it makes it exceptional. So let me stop the screen share here and take you to the slide which I prepared for you. Now let us see what does the book say. A perusal of provision of Section 33, subsection 5 indicates that the provision employ expression prior. Well, although prior leave of the court is not obtained, such leave is not a condition precedent for initiating civil proceedings. The leave of the court may therefore be obtained subsequently, even after institution of the suit proceedings. The dictionary meaning of the word approval includes ratification or ratifying of the action. Ratification obviously can be given ex post facto approval. Another aspect which is highlighted is a difference between approval and permission by the assessing authority. That in the case of approval, the action holds until it is disapproved, while in the other case, until the permission is obtained. Where the word prior is used in statutory provision, the approval contemplated therein must be obtained before the proposed action is undertaken. It is evident from provision of Section 33(5) that prior permission of NCLT is mandatory before liquidator initiates any legal proceedings on behalf of corporate debtor. A notice issued for invocation of arbitration under Section 21 of Arbitration and Conciliation Act 1996 constitutes the commencement of arbitral proceedings. In the present case, it is the admitted position that the notice under Section 21 was issued without obtaining prior permission of NCLT. The record further indicates that such permission was subsequently granted before filing of the application under Section 11 of Arbitration Conciliation Act 2020 and 1996. While the prior permission under Section 33(5) is mandatory, the absence of such prior permission before initiation of legal proceedings does not render the proceedings void ab initio. It is not Section 28. Instead, commencement of such proceeding remains ineffective until the date on which required permission is granted by the adjudicating authority. The effective date of Section 21 notice shall be the date on which the requisite permission is granted, and all subsequent procedural requirements shall flow from that date. So this is a beautiful judgment. It clears the concept absolutely. The Honorable High Court has broken it down, that's analyzed the entire setup and given as to how Section 33(5) or 33(6) is operative in the context of liquidation proceedings. And this is definitely a good read, and I would recommend my viewers to please go through the excerpts of the judgment appearing in Guide to IBC website. With this, let me take you over to the next slide. Viewers, we are on the screen of Section 35 of Insolvency Bankruptcy Code, which deals with the topic powers and duties of liquidator. Now, the topic which we are going to deal with is topic number 9, which says that the liquidator needs to be informed that the Easement Act, which has come into force in 1882, is still the same in its 144th year. The act cannot be dumped in the dustbin merely because the liquidator does not want to know it. So this amplifies adequately what a insolvency professional needs to know, how much he's supposed to be aware, though despite the fact that he's not a lawyer. Now, the case which we are going to deal with is case of ARC Research and Development Center Limited and another versus liquidator of Adya Oils and Chemicals Limited. Trustee IP LLP and others. Company Appeal Suens of 2025. In this is a very interesting case in which what happened is the corporate debtor had a plot of land, which was behind. It was a tandem land, which was behind the premises of a factory. And from the national highway, there was a lane coming in. Now, earlier lane coming in, national highway was accessible from this plot of land. But people used to come from the factory, this was behind another factory. And since the promoter of this company was related to the owner of the other factory, so people used to enter from the other factory and walk into the next premises. Once the liquidation started, the other factory said did not allow any ingress to the present liquidator. Said that whatever you do, you sell your land. And they also built in between the two land. There was a space which belonged to the other factory. They built some structure there, so there was no access. The only access was the lane which was coming from National Highway. Now, this plot of land was being sold in plots. 2 plots were already auctioned. But the third plot was in such a state that he did not have access to the passageway. So they definitely required an access through the other factory, which was in front. And the liquidator said that this particular factory, since the promoter is not cooperating, it is because of this factory. Earlier, they were getting access through this land. So because the access was being denied, the, it was impediment to auction this particular land. Hence, this particular judgment went to NCLAT. Two technical members, they, they gave opinion in favor of the liquidator. But the judicial member went on a complete different way. And he looked at the Easement Act of 1882. And he said that the liquidator is wrong. You cannot possibly, because the ownership right of the other land, it is protected. The ownership and the access is protected by constitutional rights. So this is indeed an exceptional case and deals with a particular case, particular law, which is in its 144th year of existence. And the judicial member went at length on that. So this is a must read for all, the judgment. Let me take you over to the slide which I prepared for you. The Honorable Judicial Member said the easementary rights in this country is governed by Easement Act 1882, which by very nature and deceptively complex, and they mercilessly reject any pretensions, familiarity with dealing with them. Section 15 deals with the multiple easementary rights by prescription, of which we are concerned with one specific prescriptive easement right, that is the right of way. When one permits another to use one's land as a way due to personal relationship or whether personal relationship whatsoever, the user cannot be said to have acquired a right of way as the right by prescription, as it is merely a permissive user, but it is merely a permissive user at no. That is, it is just allowed. You don't obtain a right. The factory which was which was lying in front was allowing, but that did not mean that they have the land which was behind it obtained a natural permission. No, the permission does not create a vested right, and hence the permissive use can last only as long as the permission lasts. The liquidation asset has an access from the national highway to reach it, which I told you, there was a passage. The liquidation asset being sold in parts, and that two such plots have been sold in auction, and that said pathway is available for the use of those auction purchasers. The pathway would no more be available for the portion that remains to be sold. If only the liquidator had known about the easement of necessity under Section 13, this situation would not have arisen. He could have created plots according to the easement. All the plots could have used the passageway. The liquidator needs to be informed that Easement Act, which has come in force in 1882, is still in the same in its 144th year. The act cannot be dumped in the dustbin because the liquidator doesn't want to know it. Right of property of every nature, kind, variety, and width is constitutionally protected under Article 300A of the Constitution, and it cannot be meddled with by the court. A constitutional right cannot be meddled by insolvency bankruptcy court. In the context of IBC lane crossing, IBC lane crossing is enabled to a limited extent of Section 238 of the code, but is restricted only to those legislations which overlap with insolvency resolution process designed by the court. Section 238 prevails but it prevails with those acts which come in crossroads with insolvency bankruptcy code. The Constitution does cannot. And since there was already a pathway which give access, so now you cannot say. NCLT set aside the order of adjudicating authority dated 22/1/2025 passed in CPIB. The liquidator is free to approach civil courts for establishing the right of pathway of the liquidation asset in terms of provision section 33(5). Liquidator can try whatever, but the easementary right given by Easement Act 1882 prevails. And that's what the honorable judicial member of NCLT said. So this is a very, very important thing. And this is an exception of a case which we should all know. With this, let us move on to the next topic. We are on the screen of Section 96 of Insolvency Bankruptcy Code, which deals with interim moratorium. Because the case which we are going to deal with deals with subsection 4 of Section 96, which has been inserted by Insolvency Bankruptcy Code Amendment Act 2026. So this is absolutely new. What does a subsection 4 say? The provisions of this section shall not apply where an application is filed for initiating insolvency resolution process in respect of a personal guarantor to a corporate debtor. So Section 96 interim moratorium will not apply to a personal guarantor of a corporate debtor. That means company or whatever corporate entity on whom the CIRP process or liquidation process is already commenced. So this is absolutely a new insertion, and the topic which we are going to deal with deals with this particular section. So let us move over to the topic part. The topic we are going to deal with is topic number 22, which says that moratorium in respect of personal guarantor until May 25, 2026 would cease to operate with effect from May 26, 2026 in respect of applications filed under Section 95 of IBC if CIRP is initiated against the corporate debtor. So you can well understand, going through the topic, how important this is. The cases of Tata Capital Financial Services Limited versus Neil Motors LLP and others, commercial arbitration petition number so-and-so of 21, Bombay High Court. Though this case is of 2021, the judgment is of very recent, and which takes into account the amendment of Section 96 and especially subsection 4. In this particular case, I need not say this is very important. This essentially deals with subsection 4 of 96 and whether interim moratorium is applicable or not. And SEBI circular and others, and various cases have been referred to in this particular judgment. And this makes it a must read for all. Rather to make things precise and understandable, let me take you over to the slide which I prepared for you, while recommending you to please go to the excerpts of the judgment, which is featuring on Guide to IBC website. Now let us have a look at what the Honorable High Court said. Subsection 4 to Section 96 IBC reads, the provisions of this section shall not apply where an application is filed for initiating insolvency resolution process in respect of a personal guarantor to a corporate debtor. It is evident that this amendment has been notified and brought into effect on May 26, 2026, pursuant to notification dated May 22, 2026. The phrase where an application is filed would bring within its sweep anything that is filed and is pending with the adjudicating authority as on that date. The reading of the words is filed is included in those that have been filed and are pending and will not give retrospective effect, but will have prospective effect from the date on which the provision takes effect. So it will not have retrospective effect. It will have prospective effect with when the provision comes into being, and which is May 26, 2026. Since the proceedings were initiated by none other than the petitioner, it is nobody's case that respondent had exploited any perverse incentive to use automatic moratorium under Section 96 to frustrate petitioner's recovery proceedings. So this was a 95 petition and initiated by Tata Capital Financial Services Limited. So they cannot say that 96, the personal guarantor was trying to use 96 as a shield, 96 interim moratorium as a shield for blocking the recovery process. So it was nobody's case. Nobody was blaming for that. The provisions of Section 96 as amended are agonistic to persons at whose behest the application under Section 95 of IBC was filed. The term retroactive, while being used differently in different judgments, is actually a prospective application of a newly introduced requirement of law to facts existing as on the date of the introduction of the requirement. Any application that is filed initiating an insolvency resolution process in respect of a personal guarantor to a corporate debtor would not fall within the ambit of Section 96(1) and related provisions with effect from May 26, 2026. A moratorium, insofar as it operated in respect of respondent number 2, 3, and 4 until May 25, 2026, ceased to operate with effect from May 26, 2026 in respect of applications filed under Section 95 of IBC. So the moratorium, interim moratorium, did exist till May 25. But May 26, when this Amendment Act came into being, the moratorium no longer existed. The only reason that Section 9 petition has not been considered till date is in existence of the moratorium and not laxity on the petitioner's part in pursuing it. Now that the moratorium has been lifted, it is considered appropriate to deal with it. So this is an exceptional judgment, absolutely relevant, and this takes into consideration the Insolvency Bankruptcy Code Amendment Act 2026. And this is current topic, and we should know about it. So with this, we move on to the next slide. We are on the screen of, or rather the dashboard of Section 121 of Insolvency Bankruptcy Code, which deals with the application for bankruptcy. As we all know, that insolvency of personal guarantors started very recently. So we had initially a lot of cases coming in insolvency. Now insolvencies have started getting over. So the next bout is to follow is in bankruptcy. So we have started getting cases in bankruptcy and new topics are evolving. Now, the topic which we are going to deal with in Section 121, it says that Section 121 of the Code does not mandate service of prior notice upon the bankrupt before a bankruptcy order is passed. And furthermore, the bankruptcy process follows as a natural sequel to an unchallenged PIRP closure order. The cases of Aditya Vivek Taude versus Bank of Maharashtra and another company appeal so of 2026. In this case, what happened? The PIRP was admitted ex parte. The RP made up, frequently followed up, sent emails and all that, but the party did not respond. So So the insolvency order under Section 100 was issued ex parte. Then also the RP made the public announcement. The party did not. There was no response. It wrote emails after emails to the party. The party did not respond. At the time of the first meeting, the party came and said that it will disclose, give the necessary details. However, they did not. In the second meeting, the committee of creditors decided to go for closure of insolvency. Uh, Later, after the insolvency closure was agreed by the committee of creditors, the party came and offered a one-time settlement of 2 lakhs and give a resolution, repayment plan also, which was not in the given format. So that was rejected. So then came obviously after the order was issued by adjudicating authority, the regarding closure of PIRP, the RP went in for an order for bankruptcy, which came about. The party challenged the bankruptcy order, stating that there has been violation of law of natural justice. And the matter went to NCLAT, and NCLAT gave a detailed analysis of the order. And this is very important because these cases are very important, being absolutely new. And if you go through the case, and if you go through the excerpts of the case as it is appearing in here, you will get to know how the process is done. So it gives a good amount of knowledge. So with this, let me take you over to the slide which I prepared for you. Now, the Honorable Appellate Authority said that the demand notice in requisite form under Rule 1 of uh, personal guarantee thing was served upon the personal guarantor on 28th June 2022 by speed post. During PIRP process, the RP sent emails on 25/9/2024, 3/10/2024, 9/10/2024, 14/10/2024, and 4/12/2024, and sought for data or information from the guarantor. However, no response was received. The personal guarantor in the first meeting of creditors held on 21/11/2024 through VC agreed to provide data as requested by the RP within a week's time, failing which RP had the liberty to move a petition for non-cooperation. During the second meeting of creditors, both creditors, namely Central Bank of India and Bank of Maharashtra, approved filing for closure of personal insolvency. The appellant inter alia sent email on 1/2/2025, that is after closure of insolvency by Committee of Creditors, giving personal proposal for one-time settlement of 2 lakhs, which was not acceptable to respondent 1 and respondent 2 at all. I mean, the NCLT also said that this was ridiculous against a debt of nearly 35 crores or more. The closure of IA being IA number closure, IA being IA number so and so with reserve for order on 29/1/2025 got allowed while order dated 26/6/2025. Thereafter, RP sent email on 27/6/2025 to the personal guarantor intimating passing of the closure order dated 26/6/2025. So the RP informed. Bankruptcy petition was allowed by order dated 3/2/2026. The respondents that post-closure of order of the appellant had filed IA IBC so and so before learned NCLT on 2/7/2025, seeking to set aside the closure order dated 26/6/2025, which was dismissed on 7/1/2023 to 7/1/2026. The appellant has not disclosed or attached the above dismissal order in the appeal. Thus, appellant is guilty of suppression of facts. The court has issued the Latin phrase suppressio veri and suggestio falsi, which means falsification or suppression of facts. The code provides no requirement of service of objection to a closure report under section 112, 1141, and 1152. Section 121 of the code reveals that it does not mandate service of prior notice upon the bankrupt before a bankruptcy order is passed. And furthermore, the bankruptcy process follows the natural sequel to an unchallenged PIRB closure order. Unchallenged. The SURFACE notice of 31/1/2015 was issued for enforcement of security interest and did not amount to invocation of personal guarantee. Well, we have read judgments in which it has said the SURFACE notice under 13(2) issued for enforcement of security interest, if it mentions the name of the personal guarantor, it can be considered as an invocation of guarantee. But here the Honorable NCLAT opined that SURFACE notice on 31/1/2025 issued for enforcement of security interest did not amount to invocation of personal guarantee. The personal guarantee was invoked for the first time only through demand notice dated 28/6/2022 in CPIB number so and so filed on 31/3/2023 and is accordingly within the period of limitation. However, fact remains the limitation was not challenged in the before the adjudicating authority, that is NCLT. So they did not have any right to bring up this topic in NCLAT. But however, the court did look into this aspect. The appellant has presented incomplete facts and has tried to mislead the appellate tribunal and has wasted the precious time of the tribunal and deserves to be appropriately dealt with in terms of cost. And it imposed a cost of 5 lakhs on the bankrupt. That is Aditya Vivek Karve. Well, without prejudice or without meaning anything bad, one question does come into my mind, that how can court impose a cost on a bankrupt? Because whatever money of the bankrupt is there, that goes to the institutions to whom it has given guarantee. So, though it is an excluded debt under Section 74, but there is a point of doubt in my mind. But however, there is no questioning in the wisdom of the appellate authority. So with this, we move on to the next slide.
I hope you like the presentation and you will take active role in making our website guide to IBC grow further. Your likes and your comments do motivate us a lot. So please like our video and give your comments and share it with your friends and colleagues so that people get to know about Guide to IBC more and more. With this, we look forward to coming back to you towards the end of the month. Bye for now.